So and to go off of what Jamie just said, I've absolutely seen high school students be much better advocates for their clients than professional attorneys. So
yeah. Okay. So we're going to get started, and because we're teaching the intermediate advanced group, we didn't want to spend a lot of time going over the basics. What we actually wanted to do was get you guys into competition mode. And that means that we are going to play a game of Jeopardy that involves mock trial, it involves rules of evidence, it involves all kinds of other things for you to compete with the other participants and see how much you remember from last year and how much you're ready for this year. So I didn't come up with a way to keep score for the group. So I'm going to ask each of you to keep score for yourselves, and then we'll see how that goes. I am going to share my screen, and Kevin, what I'll ask of you, and I think this will work, is I can run the Jeopardy board, but if you can monitor the chat, and we'll figure out after I read a question, the first person who puts a letter, any letter in the chat, will be the person that we'll call on to give the answer. And then if that person can unmute themselves and say the answer out loud, that would be great. For whatever reason, if you can't do that, if you'll put your answer in the chat, then you will also be the person who can be the one to choose the next clue that you're going to be giving. In regular Jeopardy, obviously, you need to answer in the form of a question. I don't care about that for today. You can just say what the answer is, just so you don't have to worry about who is, what is, and that kind of thing. And yeah, so I think we can get going. Let me share my screen and we'll see how this goes. All right. I think if I put this in presentation mode, I'm not going to be able to see everyone else in the chat. So I think I'll keep it like this if I'm able to. But let's start with single Jeopardy. So the categories that we're going to be dealing with are objection, which means that the clue is going to be an attorney question, and you have to give me the proper objection to that question. We're going to talk about rules of evidence, courtroom etiquette, what's wrong with that on direct examination. Again, you're going to see a scenario, and you're going to tell us what's wrong with that scenario, and then exhibits. So to get things started, Kevin, if you want to call on someone random to choose the first clue.
Okay. Call on someone random. Let's go with what happened?
Oh, I just put it into presentation mode, so it might have made things disappear.
Yeah, and I can't see the chat box.
Okay. Is that better?
Yeah, I can't see the chat box.
Okay, you might have to reopen it. I just put it back into regular mode.
Okay. Yeah, I can yeah, so I can see the yeah, I can see everything. Let's go with Claire Ansel.
Okay, Claire, please choose a clue from the board.
Objection 500.
All right, we're going to start with 500. Did you see the defendant on the roof? Answer, no. When you were on the roof, did you see the defendant? Can you give us the proper objection to this line of questioning? And Kevin, whoever put a letter in the chat first.
That would be Frisco CTE. Put the letter in the chat first.
That was the objection asked and answered.
Hey, what is asked and answered? Very good. All right, let's go back to the board. Which there was a better way to do this. Maybe like that. Nope. Okay, I'll do this manually. And Frisco CTE, please pick the next clue.
We'll go with rules of evidence 500.
Okay. Name 2 of the 5 privileges a witness can plead to avoid having to reveal communications with the defendant.
Where is that?
Frisco CTE.
That would be attorney-client privilege and spousal privilege.
What are spousal, attorney-client, grand jury, secrets that's supposed to be secrets of state, and psychiatrist-patient privileges? So yes, you got the 500. All right, please pick the next clue, and I'll bring the board back up.
Uh-oh. Did you unplug it?
Uh-oh. Did we lose
think-
Frisco CTE?
I
we're
think
back.
We're back. Sorry.
Chat respond.
Can you?
All right. It says you're here. We just need you to pick a clue. And you can put it in the chat if that's easier.
Courtroom etiquette 500.
Okay. Please name 2 of the things you need to ask permission from the judge before you do them.
Mark Williamson.
What are moving about the well, and what are proceeding with direct examination?
All right, what are moving about the well, approaching the witness stand, approaching the bench? But I would say that asking to proceed with direct examination is also a good one that falls into that category, since it's always nice to ask the judge for permission. Kevin, you can give your input on this as well, but I don't think it's ever a bad idea to ask the judge for permission to do any of the parts of the trial that you're working on.
Yeah, absolutely. Yeah, absolutely agree with that.
All right. So Mark, will you pick the next clue, please? And I'll bring the board back up.
Yeah, absolutely. Let's go. What's wrong with that for 500?
So we're in the context of direct examination. The question is, doctor, describe the injury to the patient's leg. Answer, he suffered a comminuted fracture to the distal femur. Question, oh, thank you. Now, moving on. What's wrong with that kind of direct examination?
Frisco CTE.
What is sidebar?
Right? So that's a possibility. Does anyone else have any thoughts on this one? What would be wrong with this kind of direct examination?
Yep. Put your letter in the chat. All right, so we've had Mark Williamson, Frisco CTE, somebody else. Sophia Reese.
It's not in layman's terms, so the jury doesn't know what that means.
Yeah, what is failing to reduce complicated terms to understandable words? And that is something that happens in my practice with expert witnesses all the time. And in mock trial, if you have a doctor or you have an engineer or another kind of scientist on the stand, it is always good to, when they start using the kind of scientific speak or engineering speak, to ask them to bring it to a level where everyone can understand what they're talking about. There's a bonus question here. So Sophia, this is for you. In the situation that we're talking about, what follow-up question would you as the attorney ask the witness?
Well, you could ask them to explain that in a way that the jury would understand.
Yeah, I think that's perfect. Kevin, do you have any other input on this one?
Not on this one. A lot of my experience, I haven't really dealt with a lot of situations involving this. So I think what Jamie said, I think what you said makes the most sense.
Okay. All right, let's go back to the board. Sophia, please pick the next clue.
Let's do exhibits for 5.
All right. I love how everybody went directly for the $500 category, and that is going to be cleared out now. The basic question and answer that you do with the witness preceding entering an exhibit into evidence. In this case, the exhibit is a newspaper article authored by the witness. And what I'm asking for here is for the respondent, whoever's responding to this, to kind of walk us through what you would do to get a newspaper article that's authored by the witness into evidence.
Anishka Balanki.
You would lay the foundation to the like about the newspaper article with the witness to lead up to asking the judge to bring it into evidence.
And what does laying the foundation look like in terms of the types of questions that you would ask?
You ask about like the subject about the newspaper, like what the newspaper is about, if they know when it's like written, like the purpose of it and all that stuff.
So yeah, you could go through some questions like, do you recognize this exhibit? What is this exhibit? Does it appear to have been altered or changed? Does it bear your byline, which is a fancy word to say, are you the author of this article? Did you create it in the normal course of your employment? Questions like that, so that the other side won't really have a good opportunity to object and say that it's not authentic or it's not what it seems to be. So Anishka, a bonus question for you. What objection or objections would you make if the witness on the stand was not the author of the article, but instead they were a person that was interviewed in the article?
Would it be a hearsay objection?
All right, Kevin, what do you think?
Yeah, I think it would. I think it would be a hearsay objection. Yeah, that's good.
All right, so everyone else, I hope as we're going through this that you're keeping track of your own score, even if you're not the one answering the question. At the end, you'll tally them up and we'll see how everybody's doing. Anishka, if you'll select the next clue, please.
Can we do 400 for objections?
Sure. Okay, here is the Q&A and you have to make the objection. Question, what happened at 8:05 p.m.? Answer, well, I wanted to wear my green shirt, but it was at the dry cleaners, so I wore my red shirt, but it had a stain on it, and I needed to iron my pants, but I didn't have time.
Neil Hiremath.
Would that be narration?
So that is a possibility. Can you explain a little bit about what part of this would be a narrative?
So I would say that this is narrative because so the witness starts out with saying, I wanted to wear my green shirt, but what comes after that is really like narrative because like they're talking about they're kind of extending it into a story like, yeah, so I wore my red shirt, but it had a stain on it. And that's just elongating it more than it needs to be.
So let me ask a follow-up to that, and anyone can answer this. If you objected to the question, what happened at 8:05 p.m. as calls for a narrative, if you were the questioning attorney, how would you defend your question?
And for this, what we could do is we could either have Neil respond or we could have one of the other chat persons respond.
Yep.
Could you please repeat the question?
Sure. So in this, what we're looking at here, if you're the questioning attorney and you asked what happened at 8:05 p.m. and the opposing counsel objected as calls for a narrative, how would you defend your question?
Well, we'd be asking for Your Honor, this question goes to a very specific point, which we want to bring up. It further, it allows the questioning to proceed. So we're asking for a very specific incident that happened at 8:05 p.m., not something that happened for the whole morning. So this would be a very narrowly tailored question.
Okay. I like that. I think that's a good defense. If we're talking about direct examination and I were the presiding judge, I would allow this question. Kevin, what do you think?
Um, generally, I would agree with that. Part of the thing about objections is they all do come within the context of the trial. And if the witness has been previously admonished for not launching into the narrative, then probably yes, I would agree with Jamie's Jamie's decision to overrule the objection. But if the witness has been previously admonished about kind of going off the rails and kind of going afield from the question, then that would change the analysis a little bit. So this is not necessarily a clear cut answer, but that should but yeah, that's kind of what I would do in this situation.
All right. And for this particular question, what happened at 8:05 p.m.? And then you have the witness launching into this whole thing that they're launching into. Can anyone think of any other objections that would be appropriate here?
Nina Uday.
I would say that the question is ambiguous or vague.
And can you explain a little more what you mean by that?
Because a lot of stuff can happen at 8:05 p.m. and you're trying to like lead them into saying something that's substantial to the case. And so you would probably want to be more specific with what you're talking about, instead of just saying 8:05 p.m.
Okay. How would you fix this question to make it less vague or ambiguous?
I would say like what happened at 8:05 p.m. When you tried to put on your green shirt, I guess.
Okay. Yeah, and adding a little bit of detail never hurts for something like that. I think a lot of times what happens is on direct examination, the witness and the attorney have practiced so many times that they just have this kind of Q&A memorized. And the witness knows exactly what they're supposed to answer when you ask them what happened at 8:05 p.m. But it's true that that could elicit an objection that it's ambiguous. And it might be good to clarify the question to say, okay, what happened at 8:05 p.m. in your house? Or what happened at 8:05 p.m. after you had dinner or something like that, if that type of information was already in the case. All right, any other potential objections to this, what happened at 8:05 p.m. and the answer that we see here?
Luke Williamson.
Possibly relevance.
Okay. Yeah, depends on what's going on. If the only information pertinent to the case is the morning, and maybe everything that happened in the case happened in the morning, then what happened at 8:05 p.m. could be completely irrelevant. That's true. So let me ask a little more of a specific question. What kind of objection would you make to what the witness answered if you were the questioning attorney?
And we'll go back. We'll go to Frisco CTE on this one.
We would do non-responsive because
Go ahead.
So we would do objection non-responsive. The witness is not responsive to the question. We're asking what happened at 8:05 p.m. and the witness is talking about things that are really not pertinent to the exact question.
Okay.
And
yeah, go ahead.
Oh, and then for Frisco CT, I was going to say, at what point in the response would you object? Make that objection.
We probably object around I needed to iron my pants because that's the level at which it's just completely outside the scope.
Because that's too much information.
Yeah.
Yeah.
Yes.
All right, great. Let me. Okay, and then a bonus question. If this is your own witness on direct and you make it's rare to make a non-responsive objection to your own witness, but sometimes you need to do that to get your witness back on track. What could you do to direct your witness back to your question?
Right.
Let's go.
Would it
Frisco CTE, you can answer this one.
So at 8:05, what happened?
So at 8:05 p.m., what specifically happened? Redirecting you back to my question. What specifically happened at 8:05 p.m.? Things like that. Sorry, 8:05 p.m.
Yeah, that's good. I really like the redirecting you back to my question, which I think a lot of mock trial participants use. I use that when I'm questioning witnesses as well, because witnesses can be nervous and they might be just rattling on because it's what they do when they get nervous. So interrupting that flow that they're going on and just saying, hey, think about my question. I think that's a really good way to get them to focus back on what they're talking about. All right, Frisco CTE, please pick the next clue.
Let's do exhibits for 400.
Once an exhibit is admitted into evidence, ask the judge if you can blank it to the attorney, to the jury.
Mark Williamson.
What is published?
That is correct. I have no idea why it's called that. I am sure that that's a term that goes back to the 1800s or something like that. But that is the proper term for, you could say show it to the jury, you could say exhibit it to the jury, but that is the proper legal term for then providing the exhibit to the jury once it's been entered into evidence. All right, Mark, if you'd like to pick the next clue.
Sure, let's do courtroom etiquette for 400.
Hey, the best way to address the people in the jury box.
Sam Batchelder.
I would say ladies and gentlemen of the jury.
And absolutely, you can say members of the jury, you can say ladies and gentlemen of the jury. In mock trial, it's entirely possible that you're going to have a jury that's made up of people of one gender only. And at that point, I would just go with members of the jury, because saying ladies of the jury or gentlemen of the jury is a little awkward sounding, but it really doesn't matter from a judge's perspective as far as I'm concerned. Kevin, what do you think?
Yeah, members of the jury is the most generic, and you're gonna have no issues whatsoever by using members of the jury.
All right, Sam, please pick the next clue.
Let's go rules of evidence 400.
Evidence of a defendant's former crime or wrongful act can be used to show motive, opportunity, or intent, but not this.
Sam Batchelder.
Character for truthfulness.
The answer is, what is that on a particular occasion, the defendant acted in accordance with that character trait? So yeah, and let's go back to the question for a second. So when we're talking about, say, in a criminal case, the defendant has been convicted of a crime in the past, or they just have done something, maybe they didn't get convicted for it, but they've committed another crime in the past, but it is somehow relevant to the crime that they are being charged with, that you're there on the trial with in that day, then you can use that evidence in certain ways. And it can get a little bit confusing as to, can you use it here, can you use it there? And ultimately that's going to be the judge's call. But to show that something like, oh, the defendant in the past had gotten into a fight with the deceased, and then maybe the evidence that of that former fight, maybe he'd been arrested for that fight, you could use that to show that the deceased at the time intended to cause harm to the defendant. That type of evidence could be used in that way, because that would be used to show intent. But you would not be able to use that evidence to show that the defendant, in the case of what the defendant allegedly did that led to the trial acted in accordance with whatever anger or aggression, which was shown by their former crime. And Kevin, I know you work in, do you work in the criminal courts these days?
I was a prosecutor in municipal court for a year, and I had one assault trial where I could have used this type of evidence, but I didn't. Because it really is tricky when to use this. And given that this year's case, I believe, is a civil case instead of a criminal case, it may or may not come up. But the bottom line principle with this is past action. Generally, we're not trying to use past action to prove what happened to prove it, but you're trying, but you can, but as Jamie alluded to, you can use it to establish minor points of, they have a propensity for this, things like that. And so if you, it's sometimes best to think of it in terms of, does what they did in the past lead them to have a propensity for that? So if you could couch it in those terms, that's generally an or a permissible way to use that information.
And we have a question in the chat about that. Would this, if you were to object, be more prejudicial than probative, or would it be improper character evidence? What do you think, Kevin?
Could you go back to the question real quick?
Sure.
Okay, so it really does depend. It's all really context dependent. I mean, you could make that objection. Now the question is, would a judge, agree to it, and what would the other side's response be? So whenever you're making objections, you have to, obviously state your objection. And then once the other side, states why, the judge may come back to you for a response. So your job is to think of the response to what their response to your question is, or to your objection is. So that sometimes does need to come into play when you're making objections. So, but to answer your question, Neil, both of those could be good objections to make. It just kind of depends on some more of the facts that we don't necessarily have based on this question. But generally, yes, those could be used.
That didn't work. Okay. All right, let's go back to the board. I think I forgot who the last person was that picked. Was it Sam was the last person to answer?
Yes, it was.
Okay, Sam, can you pick the next clue for us, please?
All right, let's do what's wrong with that direct 400.
Okay. Name 5 of the 8 best words to use to start your questions. And we're talking about direct examination.
Frisco CTE.
It would be the 5 question words: who, what, where, when, how.
Hey, that is 5 of them. Does anyone want to answer what a few others?
No, but
okay. So what we have here are who, what, when, where, how, why, or describe or explain. And those words can also be really effective in getting what you want. In case you have a question that is a little bit more open-ended on direct, and you just want to get the witness to talk a little bit about the situation, then describe or explain are also really good options. Okay, Frisco CTE, please pick the next clue.
Let's go objection 300.
All right. So the questioning attorney says, what did the police officer tell you when you saw him at Kroger? How do you object?
Sam Batchelder.
That would be hearsay.
That would be hearsay, correct. All right, Sam, please pick the next clue.
Rules of evidence 300.
Right, the court may exclude relevant evidence if the danger of unfair blank outweighs its blank value.
Neil Hiremath.
The court may exclude relevant evidence if the danger of unfair prejudice outweighs its probative value.
Let me find that. Yes, absolutely. Prejudice and probative. And for bonus points, and anyone can jump in to answer that, what rule of evidence are we talking about here?
Do we have to put a letter or can we just answer it?
You can just answer it.
That would be rule 403.
Okay, very good. Very good. Okay. Kevin, why don't we call on someone new to pick the next clue?
Yeah, absolutely. Let's go with Hope Harris Harrell. And if we okay, how about Olivia Gallinar?
Let's go with courtroom etiquette 300.
Right. The person you speak to when you make an objection.
Nina Uday.
The judge?
Absolutely. And I think it is tough, even for practicing attorneys. You get very wrapped up in the Q&A and what the other attorney is doing, that you really just want to turn to them and make your objection because you're objecting to what they're saying. And you want to tell them how objectionable they are and how much you don't agree with what they're doing. But the important thing is to remember that you never actually speak to opposing counsel during a trial unless you're proffering an exhibit. So you have to direct everything you're saying to the judge. So very good.
Even as much as you want to direct your comments to opposing counsel, you still have to talk to the judge.
Yes. All right, so Nina, please pick the next clue.
What's wrong with that 300?
All right, here is the Q&A. Question, where do you live? Answer, 3 children. Question, how old are you? Answer, 21, 15, and 8. Question, how old are your children? Answer, it happened on January 1st, 2010. What is wrong with this Q&A?
Manna William.
Okay, so in the chat, we have there's no characterization or it doesn't sound like a person. Okay, so we've got a couple of things going on here, and obviously what's happening is not great. So yeah, I mean, it doesn't sound like a person. It kind of sounds like a robot is answering them and the robot is glitching. And that's not what you want your witness to be doing when they're on the stand. So one of the things that you could also say is that the attorney is not listening to the witness's answer. And that's something that the attorney is doing wrong. When you go back here, and if Kevin was my witness and I asked him, where do you live? And he answered with 3 children, I should be thinking enough about his answers and listening to his answers that I know to go back and say, okay, redirecting you back to my question, where do you live? And hope that that gets him back on track. One of the things that, and I don't want to speak for you, Kevin, but one of the things that I've seen in mock trial from time to time is that on direct, attorneys are very focused on their script and they know exactly what order to ask questions in and what's going to happen. But that means when things go off the rails, then sometimes you can get some nonsensical Q&A like this. So even on direct, even if you've practiced it a million times, it's really important to always listen to what your witness is saying.
Yeah, yeah, and uh, and other teams know that that's kind of how some people like to operate as far as being very programmatic. So what they'll do is they'll just start objecting to things to kind of break up to see what'll happen is once you break that flow of your question and answering, they'll use the objections to see what'll happen. So it really this is while this is something that you do practice in reality, most attorneys typically don't sometimes always have this opportunity. So it's very much a listening and it's very much a listening exercise. So
All right. Mana, please pick the next clue. And you can do that in the chat if that's easier. Okay, objections for 200. Okay, so the question is, you're asking a lay witness, what do you think happened on the night of the 20th?
Anishka Valanki.
It asks the witness for an opinion when they're a lay witness and can't give an opinion.
That's right. So that is definitely asking for an opinion. What do you think? And for a bonus, who are the only types of witnesses who can offer an opinion?
Mana William. And if Mana, you can put your answer in the chat if that's easier. You can do that. All right. So expert witnesses. Yep.
Yep. So an expert witness can provide their opinion on the ultimate issue in the case, or not the ultimate issue, but in terms of a question like this, what do you think happened on the night of the 20th? If the expert, I don't know what they would have to be an expert in to answer this type of question, but they could also say, like, if it's a question like, what do you think the defendant's prognosis was? And the expert is a doctor, then that doctor can give their opinion of what they believe the prognosis is based on their education and experience. But if you asked a lay witness, like if Kevin asked me, I am not a doctor, I'm not a medical professional of any kind, what do you think the defendant's prognosis was? And I said, well, I saw on a YouTube video once that was about surgery that sometimes you get knee surgery and sometimes it doesn't work. I have no basis for giving that answer because I'm not a medical professional. And so that wouldn't assist a jury in any way, whereas an expert witness, their kind of opinion testimony would assist a jury. All right, Anishka, if you'll pick the next clue.
Courtroom etiquette 200.
Hey, the party that sits the closest to the jury box.
Lawson Duke. And Lawson,
there we go. Yep, the plaintiff, exactly. I do want to share one quick story about this, which was funny. This is beyond mock trial, but there is something in the federal rules of civil procedure where a defendant can file what's called a declaratory judgment suit against a plaintiff. And so basically they are worried about getting sued. And so they file their own suit first, even though they're really the ones who should be the defendant. They become a declaratory judgment plaintiff, what that's called. So at one point I went to court on one of these types of cases. We were the ones who had been wronged. We should have been the plaintiff, but technically we were the defendant because of the way this worked. And we actually got into a fight with the other side about who was going to sit in the table closer to the jury box. And it wasn't a fist fight or anything like that, but there were some words exchanged. And it was ridiculous. So that's the only exception that I can think of, that the party that sits closest to the jury box may not be the plaintiff. Kevin, I don't know if there's anything else that comes to mind for you.
No, that is a great I can see that happening. That's a great story.
Yeah, it's the kind of petty disagreements that lawyers can get into from time to time. All right, let me bring the board back. All right, Lawson, pick the next clue, please. Exhibits for 300. Okay. Oops. And I lost it. Give me a second. What is the first question you should ask a witness about an exhibit?
Mark Williamson.
Do you recognize this exhibit?
Absolutely. And that really helps set the foundation for everything that's going to come next. Because if the witness says, no, I don't, then the line of questioning that you are going to go through is going to be very different from if they answer it, yes, I do. So it's really good because it gives you the chance to know which of those forks in the road that you're going to go down. All right. And Mark, please pick the next clue.
Let's do exhibits for 200.
Hey, who is the second person you show an exhibit to when you're getting ready to introduce it?
Lawson Duke. Opposing counsel. Jamie, what do you think?
So in my mind, opposing counsel would be the first person that I would show an exhibit to. And then you would show it to someone else directly after that. There could be circumstances where the judge calls the parties up for a sidebar to discuss the exhibit that's going to come in. And so the first person in that situation that you would show the exhibit to would be the judge. But that's not something that happens generally in mock trial. So I would say that the first person that you're going to show an exhibit to is generally going to be opposing counsel. Does anyone want to answer who the second person would be?
And we'll go with Frisco CTE on this one.
Would that be the witness?
Yes, that would be the witness. Because once you proffer the exhibit to opposing counsel so they can be sure that there was nothing weird that happened to the exhibit and that it is what you're saying it is, then you bring it up and you can show it to the witness and then question the witness about the exhibit. Are there any questions about that? I know that the entry of exhibits and entering exhibits into evidence and all can get a little bit complicated. Okay. Frisco CTE, please pick the next clue.
Not this time.
Oh, can we do what's wrong with that for 200?
Okay, so we're on direct and the question is asked. We've never talked about this before and it's not in your witness statement, but where were you on the night of October 1st? So again, we're not asking for an objection here. We just want to know what is wrong with asking a question like this.
Sam Batchelder.
So the fact that they've not talked about it before and it's not in your witness statement means that it could be speculation or it could be something else, but that's along the lines of objections. As far as the actual question, it's a very complicated question. There's a lot of words.
Yeah, I mean, that's all of that is correct. So it's a lot of words. It's probably too many words for a question like, where were you the night of October 1st, which is how you could ask this question. Would you ever want to ask a question that you don't already know how the witness is going to answer it? Does anyone have thoughts on that? Kevin, do you have thoughts on that?
Oh, yeah, I do. The answer is no. Because with the problems, you have everything that everybody will say. So you should know what. So if you're on direct and you're asking your witness what this question, you should know what they're going to say. If you're cross-examining the other witness, you should know what the answer will be to your question, even though it's not your witness.
Yep. Because otherwise you really run the risk of the witness giving information that's good for their case that is not good for your case. And that can be true on direct or cross. I've seen that happen in both situations where you're directing your own witness and you think, I should ask them this, but you don't know what they're going to say. And then what they say is actually really bad for your case. That's just, it's not great. It's much, much safer to stick to the information that you already know. All right, why don't we pick someone new to pick the next clue?
Yeah. Let's do Leah Chinokeva. Rules of evidence for 100.
Who is the only witness that can give testimony in the form of an opinion? And I know we already talked about this one. So we can choose someone anyway, and then that person can pick the next clue.
Yeah, let's let's have Leah answer that question.
Okay. Expert witness, absolutely. And for the reasons that we talked about before, that can actually be beneficial to the jury to hear what the expert has to say based on their experience. It is not going to be particularly beneficial to the jury to hear what a lay witness has to opine on. As much as we like hearing about other people's opinions, when it comes to court, not necessarily the most useful. Okay.
Okay.
So Kevin, who's picking our next clue?
And Sylvia Montes is picking our next clue. And if we don't,
I'm here. I'm so sorry.
Oh, you're good.
I'm navigating this. Let me see. Oh my Lord. Hold on. I was not expecting that. Okay, how about exhibits for 100?
Right. We already talked about this one too. Who is the first person you show an exhibit to as you're getting ready to introduce it?
Avni Verma.
The witness, correct. Oh, I'm sorry, actually, that's the second person that you show it to. The first person you show it to is opposing counsel, like we talked about, just to make sure that they can take a look at it, make sure there's not writing on it or something else, or say you get up and you say, I'm going to introduce exhibit 3. I'm going to show it to the witness, and you bring it over to opposing counsel, and opposing counsel says, that's exhibit 4. That's the kind of thing that can happen sometimes, especially when you're getting wrapped up in the rhythm of everything. So showing it to opposing counsel first, then showing it to the witness. Okay, who's picking our next clue?
All right, Chantel Cruz.
How about courtroom etiquette for 100, please?
What is the best way to address the judge?
Annalise Parker.
Your Honor.
What is your honor? Absolutely. It's a very polite way to address the judge. In my experience, it also means that you don't have to worry about how to pronounce the judge's name, because then all you have to say is your honor. You don't have to say judge, whatever, that might have a name that you just don't know how to pronounce. So yes, I believe, Kevin, you can tell me what you think, but that is always the best way to address a judge.
Yep.
All right, who's up next?
That would be Annalise Parker.
Let's do rules of evidence 200.
Okay. I asked the court to take blank blank of the fact that the sky was blue on June 5th. Please fill in the blank.
Sophia Reese.
Judicial notice.
What is judicial notice? Very good. And I know that's something that in mock trial you take up on pretrial every now and then. It can be in the stipulations. Basically, it just means it is a fact that is so undisputable that asking the court to take judicial notice of it means that there's no need to bring in evidence of the fact that the sky was blue. Everyone agrees. It's something that you could easily look up and find to be true. And so it's something that the parties don't need to deal with. Okay. Sophia, please pick the next clue.
Objection 100.
Okay, we're talking about a murder case. The question is, what did you have for dinner last night?
Lawson Duke. And objection relevance. That is correct.
Absolutely. I guess it's possible that we're talking about a murder by poisoning case, and maybe what you had for dinner the night before could be relevant to that, but it would have to be an extremely fast case to get to trial after one day. So if we're talking about last night and you're in the trial the next day, then there's no way that what the witness had for dinner the night before could be relevant. All right, Lawson, there is one clue left, so I'm going to assume that that's the one you want, and that is what's wrong with that direct examination. You didn't see the defendant, did you? What's wrong with this type of question? And we're talking about direct examination.
We'll go with Avni Verma.
Yes. Is it leading? It is. Asking a leading question on direct is a no-no. So this type of question should draw the objection, object to leading. If you're on cross-examination, there might be other objections depending on the context, but asking a leading question on cross is fine in that circumstance. All right, are there any questions so far?
I just have a question about the one we're on right now. Could that also be argumentative?
Yeah, Kevin, what do you think?
I'm sorry, what was the question? I apologize.
Could the question we're seeing right now on the screen, you didn't see the defendant, did you? Could that also be argumentative?
So argumentative is one of those that you really can't read it, you have to hear it. And that's where your tone of voice can come into play. And that's really a subjective call based on the facts and circumstances on how it's used. So the answer is maybe. Jamie, what do you think?
Yeah, I think that if you're at the point where you've been cross-examining and you're kind of badgering the witness, and it could also be a badgering the witness objection, depending on where you are in your cross-examination, then yeah, I think it could constitute that. It could also constitute argumentative if you are, it kind of depends on your tone. It depends on the context of what you're talking about there. It could be a fair objection in that case. Okay, I do have, I don't know where it went. This is, if there are any other questions, I'm looking for double Jeopardy because I do have double Jeopardy in here somewhere. So just give me a moment while I find that. Stop the share for now. In the meantime, while I'm looking for that, I guess let's play a little side game. I want to make sure that I can find this too. Usually the way I open up the intermediate and advanced sessions is by asking everybody that after you're done with today, what college football team are you going to go home to watch? Who are you most excited to see? I'm not going to participate in this question because my preferred team is the most embarrassing team at the moment, but I want to know what everybody else thinks. So we can talk about that, and I'm going to find the rest of my presentation.
All right, we got some Sooners in the chat. We got a Longhorn in the chat. We got any Red Raiders in the chat? No Red Raiders. Tulane, they're actually having a pretty good year. I like that. It's different. All right, we got some Tennessee Volunteers. Interesting. The ponies did play last night. Let's see. And they won, which yeah. Washington State, okay. All right.
All right. So we always get a good variety of fandom when we do this, and it's always interesting to see. And this is usually the part where I come in and I say go blue, and I don't think I can do that this year. It's a little bit sad. But anyway, let's move on with Double Jeopardy. So Kevin, who do you want to pick the first clue? Actually, let me go through the categories and then we'll talk about that.
Yeah.
So the first category is everybody's favorite, which are hearsay exceptions. So you'll see a Q&A here, and you're going to say what exception to the hearsay rule you would use to try to get that question in. Next, we've got what's wrong with that for cross-examination. Then we've got what's wrong with that for witnesses. We've got name that trial. You're going to see a quote from a famous either real life or fictional trial, and then you will name what trial it came from. And then we've got a wild card category that can be anything. All right, so who's picking first?
All right, let's go with Catherine Tyree. And if we don't,
we've got her. Name that trial for 1,000. All right, going right for it. Okay, the quote. That is a lucid, intelligent, well thought out objection. Overruled. What trial does that come from?
Alexa Reyes.
I think it's from My Cousin Vinny.
Yes, it is. And that kind of statement by a judge, unfortunately, is something that you all are probably going to have to deal with from time to time at mock trial. You come up with the best objection that you know is exactly on point. It is exactly the correct rule of evidence, and it gets overruled anyway. There can be a lot of different reasons for that. Kevin, can you think of some reasons why, as a presiding judge, you might overrule a perfect, lucid, intelligent, well thought out objection?
Because I want to see how how a team that is performing well responds to something not going their way.
Yeah, definitely. And that is something that we all do as presiding judges sometimes is, okay, when you get a curveball thrown at you, what happens? Another reason I might overrule a really good objection is because if the team is making a lot of objections, but they're not actually important to that team's case, then I might start overruling some of those objections just so that the team can kind of get the hint that just because it's the correct objection doesn't mean it's the best idea to object at that time. If it's really not going to impact your case, then it probably doesn't mean that you need to make every objection that could possibly be correct. So that is something as a presiding judge that I might do. Okay, and then a bonus question for all of you. What are some reasons you might not want to make your lucid, intelligent, well thought out objection?
And we'll let Catherine answer that one.
Yeah, and Catherine says when it won't make a difference. Yeah, that's a good answer to that, like what we were talking about. If it doesn't make a difference, if you have a really good objection, but at the end of the day, it just doesn't matter, then that's something that should go through your head as you're thinking about this is I could object, but it's not going to impact how the attorney's doing, and it's not going to impact any portion of my case. I don't really care about this testimony. Then yeah, sometimes it's better to sit it out. Okay, who's picking our next clue?
And that would be Alexa Reyes.
Let's do what's wrong with that cross for 1,000.
Okay, so we're on cross-examination. The question is, you didn't go to the victim's funeral, did you? Answer, there's a really good reason for that. Can I explain? Question, sure, go ahead. What's wrong with that for cross-examination?
We'll go with Mark Williamson.
On cross, you always want to be leading the witness. You should never give the witness such an open-ended chance like that to really waste time, right? You've got a very limited time in your cross-examination. You want to get as much in as possible, and letting the witness kind of extrapolate this answer here makes you look bad as an attorney, and it wastes the rest of your team's time.
Right, very good. It's losing control of the examination, basically. You're just letting the witness describe something that they want to do. And on cross, you don't want to give the witness a chance to do something that they want to do. And that's what asking an open-ended question like that, or like the situation that we saw, giving them a chance to explain their answer could do. But as a bonus question, and anyone can volunteer for this, can you describe a situation where you might actually want the witness to keep going?
Yes, in fact, you can actually use this as a way to control the witness. So let's say you ask the witness, did you see the gun? And they start going off on a long tangent. Well, you can let them go off on that long tangent because all they're really doing is losing credibility by not answering your question. So at the end of that, you can say, well, now that you're done, and then redirecting you back to my question, you saw that gun, didn't you? And all they have left to say is yes. And now they've just gone on a long tangent and destroyed their credibility with the jury.
Yeah, I think that's a good example of a scenario where that might be the case. It could also be that you, through the course of your cross-examination, the witness is just shooting themselves in the foot right and left. And you know that if you ask them to describe the situation further, that they're just going to keep doing that just based on the demeanor of the witness and how things have been going so far. So it's a judgment call that you can make, but I would say, and Kevin, let me know your thoughts, 99% of the time on cross, you do not want to allow the witness to provide a description or an explanation for their answer.
Yeah, especially in mock trial, the results are almost never going to be positive.
Yep. So in that situation, let's go back to that slide. If the witness said, there's a really good reason for that, can I explain? If you're the cross-examining attorney, what would you say instead of letting them go ahead? And this is open to anybody.
Yeah, first one to pop up, start talking.
You would say, I'm not really looking for an explanation, rather whether or not you did attend the funeral.
Yeah, that's good. I mean, you would just tell the witness, I'd like you to answer my question. My question was, you didn't go to the victim's funeral, did you? You would just make sure that you're bringing the witness back around to your question, and that what they want to do by explaining is not something that you're asking for. So that's good. That's a good way to control the witness there. Okay, back to our board. Who's picking next?
I think that's me. So let's do wild card for 1,000.
Okay. So not used in the mock trial competition. What's it called when a party asks that witnesses be sequestered and not permitted to hear other witnesses' testimony? So this is a true wild card because it is not anything that happens during mock trial.
Mark Williamson.
What is invoking the rule?
That is correct. Kevin, I don't know if you know, I have no idea why it's called the rule in capital letters. Mark, maybe you know.
There's a specific rule of evidence. I forget the federal rules of evidence. I can't remember exactly where it is. But just invoking the rule, just common legal terms for let's sequester the witnesses, just not to bias any future testimony in the trial, right? And that happens when trials go over the course of weeks. But since we're all doing it within the span of 2 hours and everyone knows what everyone's saying, not really a point in mock trial.
Yeah. I think I learned in evidence, and when I took evidence in law school, why it's called that, but that was a while ago and I forgot.
Yeah, and just for some reason, when you say the rule, everyone knows that that's what you're referring to, is the rule about sequestering witnesses. All right, let's go with someone new to pick the next clue.
Yeah. Let's go with Price Jenkins.
Could we do hearsay exceptions 800?
Okay, we're diving into hearsay objections. Okay, what would be the exception to the hearsay rule if you wanted to get into evidence the transcript of the defendant's arson trial from 2 years ago, in which the defendant was found guilty and sentenced to 18 months in prison?
Sam Batchelder.
Would that be judgment of a previous conviction?
That is exactly right. So that is one of the exceptions to the hearsay rule. There are some requirements that you have to go through for that to apply. So it's not enough to just say it's not hearsay or it's an exception to hearsay because the defendant was previously convicted of arson. That's not going to be enough. It's going to be, you have to show not only that the defendant was actually found guilty, it's not enough for the defendant to have gone to trial, that there has to have been some kind of penalty imposed, which in this case, we've got the 18 months in prison. And there needs to be some kind of proof that this is what happened. And here we have the transcript from the trial so that you're able to show that this is what actually happened. And at that case, you can defeat a hearsay objection by saying it's the exception for judgment of a previous conviction. All right, Sam, please pick our next clue.
Let's go wild card 800.
Okay, who is the person that an attorney asks for a time check? I think Kevin stepped away for a moment, and I see the first one here.
Frisco CTE.
Okay.
Yes, the attorney would ask the judge for a time check, and then the judge would then ask the timekeeper.
Okay, that is correct. And again, that goes back to during the course of a trial, the only person other than the witnesses that the attorney generally speaks to is the judge. And as presiding judge, I would then ask the timekeepers to give me the status of the time. All right, Frisco CTE, please pick the next clue.
Although this activity goes against our Fifth Amendment right against double jeopardy, I will select hearsay exceptions for 1,000.
Okay. I like the prelude to that. That was very good. Okay. What hearsay exception would you use to get around an objection to entering the defendant's birth certificate from 1988 stating that he was born in Alabama?
All right, we've gotten some of the we've gotten some people who have some frequent responders. I may call on somebody else just to see just kind of break things up a little bit. And to do that, I'm gonna go ahead and see, and I'm gonna go ahead and call on Aiden Perales. Aiden, do you happen to know this here the answer to this question? And if you can't speak, you can put your answer. Okay. Ava Goodman. If you are a coach, could you change your name just so you could put coach next to your name, so I'm not calling on a coach to answer a question directly for a student to help kind of clear things up. And while we're doing that, we'll just have Sam Batchelder answer the question.
So I think this would be a public record. Or an ancient document, yeah.
Okay, so this particular one could qualify as either. I wanted to bring ancient documents in here though, because it's not something we see a lot in mock trial, but I think we do see from time to time. And the definition of ancient at this point is a little bit depressing. We're talking about a document from 1988. I was born before 1988, and I don't like to think of myself as ancient, but that's fine. I believe the definition of ancient is any older than 25 years. Does anyone know offhand if that's what the rule says? It's something like that.
It's
Okay.
20 years.
20 years. Okay. So I guess Kevin and I are both ancient by those terms, but that's something that can come into evidence when it is a statement in ancient documents, because the rules of evidence find that documents that are that old and that are still in the public domain are probably not going to be as objectionable as something much more current that someone maybe could have created or used in a way during the trial because they knew the trial was going to happen, or it was just something that they would have had some foresight about. If something is 20 years or older, then that's extremely unlikely to have that same issue.
If you've used a payphone, you are ancient.
Yes, exactly. Okay, bonus. And this one is tricky. Who can give an example of hearsay within hearsay and then explain how you would get each part into evidence? And answering this bonus question is going to be worth 3,000 points. There we go. Okay, Mark, what do you think?
Yeah.
So let's look at an example, right? Let's say you're working a white collar job in an office in Dallas, and Brian tells you something about some records he pulled from the archives, right? And later it's found out that Brian's being investigated for embezzlement. So you go to trial, you're a witness, and you need to testify about what Brian told you about these records. So you could get the records themselves in under the business records predicate, and you could, and if let's say Brian is like CEO, CFO, one of those jobs, right? You could say it was a statement against party interest.
Okay, yeah, that's really good. And for everybody, hearsay within hearsay is the kind of thing that, at least for me, kind of made my head explode when I was in law school, because I kind of understood hearsay, I kind of understood the exceptions, and then this thing showed up and I couldn't process exactly what it meant. It took me a while. But basically, it is that kind of situation where you have a hearsay statement that maybe is also talking about a document that's hearsay. And so it's not going to be enough to come up with an exception just to the statement. You also have to come up with an exception or a reason that the document would also be able to come into evidence. So it's really tricky. But if you can have that kind of explanation for each part, then it would be fair to be able to get all of that into evidence, even under the hearsay rule. Kevin, anything to add to that?
No.
Okay. Yeah. It's one of the trickier concepts
Yeah.
of the rules of evidence, for sure.
Yeah.
Okay. Who is picking our next clue? Let's go with somebody new for the next one.
If I call on you and you're a coach, just put it in the chat. But let's go with Lulu Hagen. Let's see if that's a student, or let's hope that's a student. Hearsay for 600.
Okay. So we're talking about the defendant in a fraud case. The statement is, I owed a lot of money to a lot of bad people. What is the hearsay exception that could get this statement into evidence? Okay, and I see Frisco CTE. How would you get this in?
That would go under 801D2 party opponent.
Okay, so, and I think the question that I asked could have been a little more specific, because I think in some circumstances it could be a statement against party opponent or a party opponent. It could also be a statement against interest when we're talking about the defendant themselves. So that you could get that statement in two different ways depending on the circumstances.
Yeah, but I also believe that party opponent is more all-encompassing, because if the defendant does testify, you would not be able to use statement against interest, as the declarant would be available. So 804 would not apply. I'm sorry, yeah, 804 would not apply.
Okay. So yeah, and again, talking about there's a bunch of hearsay exceptions. There could be several options for some of these types of statements, but that definitely works in this circumstance. Okay, Frisco CTE, pick our next clue.
Let's go, what's wrong with that witnesses, 4,000.
Okay, the last $1,000 clue. Question, why do you think the defendant killed the victim? Answer, or objection, calls for speculation. Answer, well, I think it's because the defendant hated the victim. What did the witness do wrong here?
William Manna. And if it's not William Manna, we'll go with Luke Williamson.
The witness responded when there was an objection.
Okay, and then we also have William Manna in the chat. Is it because of being the attorney's opinion? Okay, so we're talking about what the witness did wrong here specifically. And when we think about the fact that, first of all, the attorney asked a bad question. The attorney asked a lay witness, why do you think the defendant killed the victim? And so that calls for speculation. It could also call for an opinion. It's a proper objection. And then the witness goes on to answer. So if you're the witness in this situation and you have heard that question, but then also heard that objection, what would you say as the witness? And this is to anybody.
Could you potentially say it was common knowledge that the defendant hated the victim?
Yeah, and I think it would depend on whether you're on cross or on direct. If it's a question that you want to answer because you're on direct, then I think that's a really good way to answer it, is just, it's not speculation. Everybody knew this. And I think that is a way that you could answer this. If this was a question asked on cross-examination and you're the witness and don't want to answer that question particularly, how would you respond to the questioning attorney? Could you say something like, I don't want to speculate, and then see what happens from there? That's probably what I would do, and that what I would encourage any of my witnesses to do, that if the cross-examining attorney is asking you to speculate, to get into your answer the fact that they are asking you to speculate. Because then if we're talking about the trial testimony that the jury is hearing, they have that in mind before they actually hear your answer. It could be that the judge is going to require you to answer this question anyway. They might not, but they might. And if they are going to require you to answer the question, then it's good to be able to kind of situate your answer in the framework of speculation. So that is something that a witness can do in this circumstance on cross. Kevin, any thoughts on that?
No, I think you handled it pretty well. Yeah, yeah. When you're asking why, as an attorney, indirect or indirect especially, it's usually not a good idea.
All right, who's picking our next clue?
We'll go with William Manna.
Name that trial for how much? 800. Okay, here we go. Name that trial that this quote comes from. The rules of hair care are simple and finite. Any Cosmo girl would have known. Right, and who is giving our answer? It looks like the first person that popped up in the chat was Sophia Reese.
Legally Blonde?
That is correct. That is at the last part of this movie when Elle Woods gets the breakthrough in the case when she realizes that the witness that she is questioning had had a permanent the day of the murder and could not have been in the shower at the time she said she was in the shower and actually was the murderer. So something that probably wouldn't happen in a real trial, but is kind of iconic in the world of movie trials. All right, Sophia, pick our next clue, please.
What's wrong with that cross for 8?
Okay, so we're on cross-examination. The question is, you murdered the victim, didn't you? And the witness answers, I can't believe you would ask me that. You're a terrible person. I hate you. You're the murderer. What's wrong with the witness answering a question like this on cross-examination? And I'll say there are a lot of things wrong with it, so you can just name one.
Savannah staff.
I would say the witness is being incredibly hostile. Personally, I would not do that, but yeah, that's what I would say.
Yeah, absolutely. How is the jury going to react to a witness that answers that kind of question that way? It is very hostile, and a witness always has to keep in mind what the jury is thinking. So it's important to be able to have the back and forth with the attorney that's questioning you, but it should always be in the back of your mind as a witness. If I answer this question this way, what's the jury going to think? Okay, Savannah, if you will pick our next clue.
Could you go back to that? So, Jamie, do you think that this would also be an example of unfair extrapolation for saying you're the murderer? If the witness is on cross, if the witness is saying that to the attorney?
Yeah, I think the question is probably really unfair too, to
Yeah.
use on cross. It's I mean, it's the ultimate issue in the case.
Right.
So that would be a problem for the cross-examining attorney to ask it like that. There could be a situation, I'm trying to think of what it could be. It could have to do with the meaning of the word murdered. Maybe that could come into play.
Yeah.
That if the cross-examining attorney is going through and listing all the elements of murder, I don't know. There could be a circumstance where it would be permissible, but I think most of the time that's a bad question and it's a really bad answer.
Yeah.
Okay. So I think we're back to Savannah to pick the next clue.
Let's do name that trial for 600.
Okay. The quote from this trial, you can't handle the truth.
Avery Kazmarek. Correct. It is A Few Good Men.
Very good. Let me make sure I didn't have a bonus on this one. I did not. Okay. Yeah, that is the trial from the movie A Few Good Men. Okay, Avery, what are we going with next?
In that trial for 400.
Here we go. Oops, and I lost it. Okay. Blank isn't on trial. Civilization is on trial. And a hint to this one, the lawyers really monkeyed around with this one.
Luke Williamson.
Would that be the Scopes monkey trial?
It sure would. And this is the trial where basically the theory of evolution was on trial. And something that I think I learned about in science class when I was in high school. But it's also a really, really famous real life trial. Okay, Luke, please pick our next clue.
Let's go. What's wrong with that? Witnesses for 800.
So we're talking about the witness here, and we're going to say what's wrong with what the witness is saying. Question, you wrote in your diary that you never liked the defendant, correct? Answer, I can't remember what I wrote in my diary. Question, but you wrote down that you never liked her. Answer, okay, if you say so. What's wrong with the witness answering that last question in that way?
Ava Goodman.
I would say that the witness doesn't know like whether or not like what is correct, so they would totally lose points and get impeached because they didn't know what was in or wasn't in their fact statement.
So that is definitely one issue, is if the witness can't remember and it's something that's in their fact statement, then the attorney could then say, okay, here's your diary, or here's your fact statement where you talked about what's in your diary. Didn't you say blah, 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 and get impeached? Could there also be a problem with the witness just giving in to the attorney at this point? Because at first the witness said they don't remember. The attorney then comes back around and says, okay, but didn't you write this? And it seems like the witness is getting kind of tired or just doesn't want to deal with the questioning anymore and is just giving in. So this would be an example where a witness just needs to stand their ground. If they know that they're correct in what they're saying, which is what they don't remember, then even though it can get uncomfortable to do this, they just have to they have to hold the line on this one. And that's one of the hardest things for witnesses to remember to do, is at some point, you kind of just want to move on with the questioning. You don't want to just keep saying the same thing over and over. And of course, at that point, the witness's attorney can come in and say asked and answered and object to asked and answered. But if the attorney isn't doing that for whatever reason, then the witness just needs to stand their ground and keep testifying to what they know to be the truth, even though that can be hard to do. Kevin, any other thoughts on this?
Yeah, and this is where the attorney should be listening to the questions that are being asked of their witness on cross. So, if this were a cross-examination situation, this is where you would really want to be listening for so you can make your objections.
Yeah, definitely. Okay, Ava, please pick our next clue.
Let's do what's wrong with that for 600.
And do you want for cross or witnesses?
I'm sorry, cross.
Okay. To an eyewitness, who do you think murdered the deceased? What's wrong with asking that kind of question on cross?
Leah Chidokeva.
Asking for an opinion. Yeah. Anything that starts with who do you think, that's always going to be an opinion. And also asking who murdered the deceased. I mean, that can come at the ultimate issue, depending on if that's the issue in the case. So yeah, you're asking the witness to speculate. That's another problem. And also you're on cross. It's a non-leading question. There are some circumstances where you can ask a non-leading question on cross, and that's okay. For the most part, especially when you're getting to the tougher issues in the case, if you're the cross-examining attorney, it's usually better to ask the questions in a leading manner. You're just going to get better answers that way for the most part. Okay, Leah, pick our next clue, please. What's wrong with that witness for 600? Okay, so we're talking about what the witness says here. Question: you'd never met the defendant before that party, correct? Answer: right, but my brother did. Can I tell you about that?
Savannah Staff.
I think that it's like hearsay because I personally didn't, but someone I know did. So I'd be telling everybody what they said. So it would be hearsay, I think.
Does anyone else have thoughts on this one? Okay, and certainly if the witness went on to answer and wanted to talk about what the brother was doing or what the brother told them, then that would be a question that called for hearsay. And in this circumstance, it's also volunteering information. The witness doesn't have to talk about what their brother was up to. All they have to do is answer the question. So there could be a reason that the witness wants to do this. It could be that the witness hates their brother and they want to get them into trouble. But it's not answering the question. All they had to do was say correct or right. Now they're just volunteering information. And so that's not going to be a great way to get the witness to be able to make their case. Okay, Savannah, the next clue, please.
Let's do what's wrong with that cross for 400.
Okay, this is kind of a long one. And we're talking about cross-examination. You brought the knife on Friday, correct? Yes. You brought the knife with you to the party. Yes. Which was the day after you'd had a screaming match with the deceased. Yes. And you were still angry at the deceased. Yes. So you proceeded to murder her at the party with the knife. No, of course not. Where did the cross-examining attorney go wrong here?
Mark Williamson.
So this is an example of asking the last question, right? The goal of the attorney is not to tell the jury what the attorney wants them to think. Rather, it's to give them the tools to come to that conclusion themselves, right? So the problem here is really twofold. One, the attorney has told the jury what the jury is to think. And two, the attorney has asked the witness a question that the witness clearly will not answer, even if the rest of these answers are true. You want to stop right before asking that last question to make the jury think all these circumstances, right? Where does this logically lead? But by asking that question, you diminish that power of making the decision yourself in the jury's mind, and you get the witness to happily disagree. And it sounds like this is at the end of a cross, so just ending on a really weak point, right?
Yeah, it's a really good explanation. It's something that lawyers in practice struggle with, because you'll get into your head that this is going so well. This witness is answering yes to all of my questions. I just want to tie this up in a bow. And asking that last question, though, is going to get you a result like what we see on this slide. It's usually not going to work. But if you ask just the 4 questions that come before it, and you're getting these great yes answers, that is all you have to do. And were you still angry at the deceased? Yes. Pass the witness, and you just move on from there. So knowing when to stop is a really important skill in mock trial and when you're an attorney.
Yeah, so I learned from, so I had a situation where I had a defendant where the more chances I gave him to speak, the more that he would take advantage to say whatever was on his mind, and that was not good for me or anybody else in that court who heard what he had to say that day. So yeah, so the once you've made your point, that's it. Pass the witness.
Yep, definitely. Okay, I think we have time for 2 more in double Jeopardy, and then we're going to move on to final Jeopardy. So Mark, can you please pick our next clue?
For sure. Let's do name that trial for 200.
Okay. If the glove doesn't fit, you must acquit. And as a hint, this is a real life trial.
Avery Kazmarek.
O.J. Simpson.
Yep.
Absolutely, that is correct. That was the defense that O.J. Simpson's attorney came up with in court that actually was, I believe, maybe not single-handedly, but largely responsible for his acquittal at his criminal trial. Because there was a glove and he had O.J. Simpson try on the glove that was found at the scene. It didn't fit, and this was what he told the jury. If the glove doesn't fit, you must acquit, and the jury did.
And I will overlook what you did with the term single-handedly there.
Oh, that wasn't even on purpose, so thank you. Okay, Avery, can you pick our last clue in double Jeopardy, please? Hearsay for 400. Okay, this is a 911 operator saying, the caller said, OMG, he killed Kenny. What exception to the hearsay rule would you use to get this statement into evidence?
Neil Hiremath.
Would that be excited utterance?
Indeed it would. So that's an excited utterance that the 911 operator heard. And so that is permitted to come into evidence because someone who makes a statement like that when they are excited because somebody just killed Kenny is more likely to be reliable and something that the jury can hear as evidence because it happened in that moment. So in most cases, the 911 operator will be allowed to report on that. All right, we're going to move on to Final Jeopardy. So everybody make your wagers, decide how many of your points you're going to risk. I will scroll up so you can see what the category is. Okay, the category is timekeeping. So go ahead and make your wagers, and then I will tell you what the clue is, and you'll have 30 seconds to answer it. So however many of your points that you want to risk on the category timekeeping. All of them. Okay, let's go. Okay, here we go. The question, Final Jeopardy, is the total number of minutes in a full mock trial round, assuming there are no objections or other breaks. So you have 30 seconds, and then we will get to the answer. Okay. Is everybody ready with their wagers and with their answers? The correct answer to the total number of minutes in a full mock trial round, assuming there are no objections or other breaks, what is 110 minutes? Who had that answer? Okay, we've got Sam, we've got Mark, we got, well, Luke said E, but I think that's an E. We've got Sophia. All right, good job, everybody. And now, depending on what you wagered on this question, if you want to put your final point tally in the chat, we can see how everybody did. And in the meantime, while you're doing that, we have a couple minutes that we can still use for questions about anything we talked about. The only thing that Kevin and I cannot talk about is the actual problem that's going to be used this season for mock trial, but we can answer basically any other questions that you might have. And I think everybody is adding up points right now, so we can take a second while you do that. 14,000 points, that is very impressive. 3,600, really, really good. $20,000 points, all right. All right, and while all this point addition is going on, Kevin, do you have any parting thoughts you want to share?
So what I would say is, you know, we focused a lot on kind of the attorney side of things, but let's talk about witnesses because, so this is the advanced group. So I'm presuming that, you know, you guys know how to get evidence in, you guys know how to ask, you know, to script a direct, to script across, and how to answer that sort of things. And those are all well and good. This is an advocacy competition. So a big part of advocacy for both witnesses and attorneys is how you speak. It's not, you know, it's, you know, I stutter. I have a stutter. Like I deal with that. Like, and it's sometimes hard to say things the right way. And nobody's, if you have a stutter, nobody's going to penalize you for that. But what I'm trying to say is, you notice how in the video of the national high school mock trial from last year, how there was pacing and speed changes in how they spoke and how they would present ideas, and then they would slow things down, and then like make a point really loudly, and then kind of soft. That's kind of that's an important piece of being a good advocate, is knowing when to increase the volume and to decrease the volume, to increase the speed and then decrease the speed. That's an important element of being a good advocate, in addition to all of the legal mechanical rules that that you have to learn and have to know to be a good advocate for this competition.
That's a really, really good point. And the kind of thing that you can practice and that your teammates can tell you, they can give you feedback on your presentation style and like, hey, you know, that sounded a little monotone, maybe change things up a bit. Things like that can be really helpful to practice with other people, especially when you're going through what your examination is going to look like. Same thing for witnesses for direct. If you already basically know what you're going to say, then that's something you should practice, not just with the attorney who will be taking your direct, but with your other teammates too, to make sure that everybody thinks that what you're doing is compelling enough to score you points. Okay, and then we have in the chat, I really like the attorney moving to the witness stand to tell the jury what they would hear from the witness stand, or in the video. Yeah, I agree.
Yeah.
Yeah, and I think judges differ on how much eye contact with the jury they like to see in mock trial. And it can really range for me. It's not something that I will give or deduct points for generally, but I like to see that an attorney is focused on the witness. I like to see a witness focused on the attorney, but I also like to see a witness turning sometimes to talk to the jury. I think it's good to have a little variety there. And that kind of goes to Kevin's point of just changing things up a bit, because I think the jurors can get a little bit, as things go on, the jurors might get just a little bit caught up in stuff. And then that changes up the pace, and then maybe can realize, oh, this must be really important because now the witness is talking to me. So that can be another method that you can use that can be helpful to change up your pace. All right, any other questions? We've got a couple minutes left. And if not, I just want to thank everybody very much for participating today and for answering our questions and asking questions. And we wish everyone the best of luck in your mock trial seasons coming up.
Yep.
All right, thanks. And I can stay on for a couple more minutes if there are any other questions, but otherwise, everybody have a great day.
All right. Hey, Jessica, Jamie, I'm gonna head out. It's great seeing you guys.
Okay. Kevin, thank you so much for your help. Really
You're
appreciate
welcome.
it.
You're welcome. All right. Bye-bye.
Bye.
Jamie, recording, you can stop it at any time.
Okay.